All right, we're going to shift a little bit to a different section called Assignment of Interest. It's section 122.201 through 122.206. And I know that's a lot of different subsections, but this is fairly short. The reason I thought it'd be important is because we come across some heirs who don't necessarily get along with each other. It happens a lot, actually. But in Texas, you don't necessarily have to be in agreement with each other to petition to liquidate for your share. Or, as this video will cover, you can sell your share or assign it, and we can discuss that another time on how to get a fee for that. But let's begin. So let's use a scenario. Clearly you can see what's on the screen. Descendant dies, person passes away, they inherit 100 grand. They can assign that interest as a gift to any new recipient. However, if there are child support arrears involved, there will be some issues that need to be addressed. Also, there is notice to the representative. If there is no actual notice, the assignment is still valid. The representative is not liable for transferring property if the notice, child support notice, is not publicly posted as a lien, etc. So, to talk about it, while you read that image, grandma dies and leaves grandson 10,000, and he decides he wants his friend to have it. By law, the grandson can sign paper to give his inheritance to his friend. But if he owes child support, he cannot give the money away and avoid paying what he already owes. The law lets people transfer their inheritance, but it does not let them use it to transfer or escape child support obligations. In Texas, it specifically says child support, but there's another. If there's a trust that doesn't allow you to sell, which we'll go over on the next slide. But basically, this deals with the assignment of inherited property. An heir, beneficiary, or person receiving property from a will can transfer their interest to someone else. However, like I said before, there is an important exception for child support. If the inherited property could be used to satisfy delinquent child support that has been properly established, the assignment may be ineffective to that extent. You cannot transfer away inherited property to avoid child support. So let's move on. Now, on the screen, you can see 122.202, which talks about filing. An assignment may, at the request of the assigner, be delivered a file as provided for delivery or filing of a disclaimer under subchapter C of chapter 240 of the Property Code. The assigner may deliver or file the assignment. Just record the agreement. Failure to comply does not affect it. 122.204, failure to comply with chapter 240 does not affect an assignment. You don't have to record it. Even if you do not follow all of the rules in chapter 240, your assignment still works. And of course, I will cover some of that information in that chapter in a different video. And as I stated earlier, it can be a gift. Section 122.205. An assignment under this subchapter is a gift to the assignee and is not a disclaimer. Disclaimer means someone who rejects their claim under chapter 240 Property Code. So it can transfer to another person as a gift, not a refusal of inheritance when done so. And last, this is what I was talking about in the trust, the spendthrift provision, 122.206. An assignment of property or interest that would defeat a spendthrift provision imposed in the trust may not be made under this subchapter. So basically what it says, if the trust says you cannot gift your inheritance away, you cannot assign it, and that provision is in writing, then you can't do it. And that's pretty much it for this chapter. So let me talk about it a little further. If you inherit property, you can usually give that inheritance to someone else. That's called the assignment of interest. There are rules that protect children who are owed child support and the trusts that were created with special protections. The big ideal is simple. You can usually transfer your inheritance, but some protections cannot be transferred. Chapter 122 allows an heir beneficiary to assign their property to another person. That's basically it. But the law prevents assignments that would violate a valid spendthrift provision in a trust and protects child support claims. So, in closing, to summarize it up, this teaches you that if you inherit property, you can usually give that inheritance to someone else. The law calls this an assignment of interest. However, there are rules that protect children who are owed child support and trusts that were created with special protections. The big ideal is simple. You can usually transfer your inheritance, but some protections cannot be transferred away. If you have any questions, give us a call, 866-800-NOFA, that's 6632. Once again, it's 866-800-NOFA. I'm Jonah Wilson. You can visit our website. We have blogs, dating years. I hope you enjoyed this information. I look forward to making more. God bless.